webinar is entitled Protecting Your Patented Technology, Graphic Arts Patents, Trolls, and Searchable Databases. Our esteemed presenter today is alumnus Dr. Harvey Levenson, Professor Emeritus and past Director of the Graphic Communication Institute at California Polytechnic University. Dr. Levenson is an active researcher, consultant, expert witness, and speaker on matters related to printing, technology, digital imaging, graphic arts patents, copyrights, trade secrets, media, and communication, and he has authored many articles and books on these subjects. He has been a technical consultant to approximately 250 printing and related companies and has conducted numerous seminars and workshops on traditional and digital printing, including variable data printing. Dr. Levenson is also featured in a documentary movie update entitled Harvest of Wisdom, tracing the evolution of graphic communication from the dawn of civilization to the present and prospects for the future. Dr. Levenson has a lot of ground to cover today, so let's get started. Welcome, Dr. Levenson.
Hello there. Hi, everybody. Welcome to my webinar. Those of you on the East Coast, this is your lunch hour, so I hope you have some lunch in front of you. The rest of us, well, I hope we have a nice cup of coffee in front of us. I know I do. First, I want to say how thrilled I am with the recent appointment of Dr. Greg D'Amico, Administrative Chair, School of Media Sciences for the RIT College of Imaging and Arts and Sciences. I know Greg for many years, and I applaud this appointment of a highly respected, he's really a highly respected professional who is going to bring the School of Media Sciences to a new level of superiority. So all of you alumni out there, let's all come behind Greg. Let's support him. Let's provide him with whatever support he needs to really raise RIT's School of Media Sciences to its next level of superiority. I know I'm going to, and I hope the rest of you will support him as well. A little bit more about myself. I am a 1967 RIT School of Printing alum. From RIT, I went to graduate school and developed what is now a 54-year career in the graphic arts, and I like to think that I'm just getting started. While I recently retired from Cal Poly after 30 years as a professor and department head, I have not retired from the industry. I continue to write, publish, speak, consult, and serve as a sought-after expert witness specializing in intellectual property and technology, and particularly on patents. So it's this latter involvement that is the focus of this webinar. So I've been an expert witness on intellectual property for about 25 years now. I've been involved in some of the largest and most visible cases in the graphic arts industry, including the largest. Because of non-disclosure agreements, I won't mention the players. However, it had to do with technology employed on very large multi-million-dollar printing presses. I presently have several active cases, including a very visible patent troll case impacting the survival of many companies and jobs in our field. The demands of patent trolls amount to nothing less than extortion. And for those of you that are alumni from other RIT disciplines, believe me, this can and is happening in other industries as well. All you got to do is plug in the name of your industry and what I'm going to be talking about when I refer to the printing industry, and you'll know what's going on in your field as well. So this is the 5th presentation on this topic that I have been asked to do over the past year. I presented at Recycling Times, that's RT Media Conference in Wuhan, China. I did it remotely from my home, but it was a big conference. I presented at the RT Media Toners Conference in Las Vegas. I presented at the International Graphic Arts Education Association Conference at Cal Poly, where 17 nations were represented. Most recently, I did a seminar at Graph Expo in Chicago, and today, of course, I'm doing the Me RIT webinar. So anyways, we're going to be talking about an international issue here. Patent issues are increasingly international issues as nations interweave technology and legal bodies internationally are trying to establish standards that apply to all. An analogy would be Intelsat. This is the International Telecommunications Satellite Organization that regulates the placement of communication satellites over 100 nations in the geostationary orbit, which is 22,236 miles above the Earth's equator, so that they do not interfere with each other. Therefore, nations around the world, friends and foes, are cooperating on this important matter. The same needs to happen in the area of patents. Now, in the United States, California is on the West Coast. However, I like to say that California is on the east coast of the Pacific Rim, because that's where the present patent action is taking place, particularly in China. Indeed, as I will soon address, China has made amazing strides over the past 10 years in digital communication technology development. And this is reflected in the many patents developed in China since 2004. So let me talk a little bit about software patents. There is a patent troll epidemic taking place facing the world due to the proliferation of software patents. I'm going to talk more about this a little bit later on. But this refers to the purchase of patents by companies having nothing to do with the technology that the patents represents, nor do they have plans to construct, actualize, and sell the technology that the patents teach. Their only plan is to sue or ask for hefty license fees of OEMs as original equipment manufacturers, remanufacturers, or service providers such as printers who use any technology that even remotely resembles what the patents teach. As I previously mentioned, this amounts to nothing less than extortion that jeopardizes company survival and that jeopardizes jobs. What is particularly troubling is that the alleged violators are giving in to these troll plaintiffs because it often costs less to give in than to become involved in lengthy lawsuits. The starting fee to enter into a patent litigation game could be somewhere around $250,000 or even more. But even worse, ladies and gentlemen, many of these patents can be invalidated by prior art. That's published evidence of the existence of patent claims that had not been disclosed when the patents were applied for. If challenged, these troll-held patents can be invalidated. And I'm going to tell you how we can do this a little bit later on in this webinar. A significant percentage of challenged patents are won because all relevant prior art had not been disclosed at the time of the patent application. I've heard figures such as 35% to 85% of challenges to patents, and particularly those held by trolls, are won due to discovery of prior art after a patent has been issued. So what we are doing about this, what are we doing about this? At Cal Poly, we developed a specialized library for the discovery of prior art. It's called the Raymond J. Prince Graphic Arts Collection that we've developed at Cal Poly in helping the industry discover such prior art. This is the largest collection of its kind in the world, with over 30,000 titles dating back over 200 years or more. The collection, interestingly enough for you RIT grads, honors Raymond J. Prince, an RIT School of Printing alumnus of the class of 1965. Ray Prince is a dear friend and colleague of mine and one of the most visible technical experts in the graphic communication industry. Much more on this later. Let me go to my next slide here. Let me talk about the international picture. A number of years ago, I did a study, a 30-year study. I studied all graphic art patents from 1968 to 1997. That was 22,552 patents. It took me 3 years to do this. Now, I have a lot of data. This was highly published. It was published in scholarly publication and industry publications. But let me kind of give you an idea of how these patents broke out. I did a content analysis, okay? So 86% of those 22,500 plus patents were produced in the United States, 19,498. 12,800 came from the United States. Germany produced 3,580, and Japan produced 3,118. Now, today's production has changed. Now, I've worked on a lot of cases. I've worked on a lot of high visibility cases, as I mentioned, and I know what changes took place, and I know where these patents had been developed. We're going to talk a little bit about that right now. First, I want to tell you that the two greatest areas of patent activity in the world is in pharmaceuticals and software. In the pharmaceutical industry, companies are sitting there waiting on a day-by-day basis for drug patents to expire so they can jump in and produce generic drugs or new titled drugs under their company names. But the second most activity is taking place in the software area, in all industries. And why software? It's because software is the invisible technology. You can't see it, you can't smell it, you can't touch it, it's totally invisible. And software has become a prime target for trolls because it's not tangible. So we're going to talk a little bit more about this in a while in this webinar. Now, getting back to the world picture, here's what today's greatest areas of patent activity look like. So we looked at digital communication from 1998 to 2013. The United States and Japan continue to be in the forefront, but then China emerges. If you look at the pie chart I have on this graph, you'll see that while the United States is still producing the most patents, China is very close, and Japan is still an active player. But look what happened to Germany. Germany virtually disappeared, and there's very little activity in patent development in digital communication in Germany today. But it's China that has really emerged as a key player in this area. So the issue of trolls creates a moral dilemma. So these are companies that really are not interested in the technology that the patents teach, but they're interested in gaining resources, gaining income by suing companies that are using technologies that some of these patents even remotely teach, or asking for very hefty licensing fees to use the technology. And company survival is at stake. Jobs are at stake. A lot of these companies can't afford these hefty fees. Some are asking $75,000, $85,000, $100,000, or more than $100,000 to use the technology that these patents teach. A lot of these companies using these technologies and have been using them for years are small to medium-sized companies. This can mean the difference between staying in business and going out of business. They can't afford to enter into expensive lawsuits, so some of them are trying to pay these fees. And what happens is it affects their bottom line. Employees are losing jobs. They can't support as many jobs in these companies as they previously was able to. So it's really a moral dilemma facing here. We're in a society today with a lot of emphasis on creating new jobs in different industries. And what the patent trolls are doing, they're creating a situation where jobs are disappearing. So a little bit on the background of troll issues in the graphic arts. These companies that have these patents, purchase these patents, they do not produce the product that the patents teach. All they want are licensing fees, royalties, or lump sum payments. And defendants often cannot afford, as I said before, to enter into these expensive lawsuits and settle. Now, here are some other issues related to the industry and OEMs, original equipment manufacturers. Small to medium-sized companies are most vulnerable because they can't afford to enter into lawsuits, and they could hardly afford to pay the fees being asked to use the technologies that these troll patents teach. OEMs are vulnerable to being sued by users for alleged violation of patents. So you have the OEMs who develop the technology. They're being sued by the trolls. Then there are the users of technology who never even considered that patents would be an issue that they have to deal with. They're now suing the OEMs for not informing them that there were patents in existence that they may be violating. Now, this whole issue has been brought to Congress. This is a really big deal. This is not a small thing. I'm going to play for you right now a 15-minute video of the PII president, Michael Macon, addressing Congressional Senate Judiciary Committee in Washington, D.C. This took place not too long ago. So, Jerome, please go ahead and run the video.
Michael Macon is the President and CEO of the Printing Industries of America. Position he's held since 2002. Also familiar with my own background as a son of printers. He's originally from Montreal. He formerly served as President of Canadian Printing Industries Association. Degree in journalism from Carleton University, Ottawa. MBA from the University of Phoenix. And Macon, good to see you again. Please go ahead, sir.
Thank you very much, Mr. Chairman and Ranking Member Grassley. It is indeed a privilege to address the members of the Senate Judiciary Committee on a topic that is very near and dear to printers all across America. It is also an honor to speak on behalf of the largest graphic arts trade association, along with its affiliates from coast to coast. If ever there was an industry that typified small business in the country, it is the printing industry. There are more than 30,000 printing plants all across the nation in virtually every town and city. Our industry is predominantly a family-owned industry, with 80% of companies employing fewer than 20 employees. In the aggregate, 800,000 Americans earn their livelihood through printing. The roots of our industry date back hundreds of years, yet its modern face is high-tech and innovative. It must be in order to survive. Today's print marketplace is all about using an innovative cross-media mix to drive the economy. Unfortunately, we are also an industry that has attracted the attention of patent assertion entities, or patent trolls. We believe this is the case because we are, in fact, small businesses and vulnerable to predatory legal actions which threaten our very viability. Prior to 2013, it was unheard of printing companies to be accused of patent infringement. This is no longer the case. Currently, we know of at least 8 patent trolls that are seeking licensing fees from printers or threatening costly litigation. For small printers especially, this is often their first experience with patent law and civil litigation, not to mention trolling. And they are astounded by the thuggish actions of these enterprises and the dollar figures associated with their demand letters. One extortive letter issued to a Kansas printer with just 40 employees demanded $75,000 in licensing fees. If they did not pay within 2 weeks, that would go up to $95,000. This is reprehensible. Needless to say, threats of litigation are intimidating and place undue stress on an industry already struggling with low profits and challenging demand. Our average printers are forced to spend anywhere between $10,000 and $15,000 just to hire lawyers initially to protect themselves. One of our members in Colorado reports that he literally is bogged down under a stack of patent claim charts, and his business has had to take the back seat. This is a very common story all across America. Keep in mind, Mr. Chairman, that patent trolls do not innovate. They do not promote economic growth. They do not contribute to the good of education or scientific research. Most importantly, patent trolls do not create jobs. Our businesses do. And yet their actions threaten job creation. They hinder entrepreneurship and, most frighteningly, intimidate hardworking Americans for standing up for their rights. I've heard from dozens of companies who are even afraid to share their experiences for fear of retribution. In my written statement, I've included a chart that details the known patent infringement actions against the printing industry. Some of the technologies involved include computer plate workflow, which is a ubiquitous process that has been used in printing plants for more than 15 years. Web-to-print ordering and inventory systems used in our industry and countless others, and quick response codes used in advertising mail, magazines, and other printed material. I cite these example senators because I can assure you, if you were to ask small printers in the states you represent, the vast majority would tell you that they consider using the above technologies as essential to their business. That they now even fear being competitive because of patent trolls, who have no intellectual or innovative skin in the game, is also reprehensible in our view. Our overriding position is that legislation should demystify the patent process for end users, like small printing companies, so that their burden can be minimized and their solutions less costly. A number of reforms are critical. Cracking down on the deceptive behavior that accompanies bad faith demand letters is one example, and kudos to Senators Leahy and Lee for this provision. Reforming the system to include heightened pleading requirements to increase transparency, as promoted by Senator Cronin. Allowing businesses threatened by similar suits to pool resources through an expanded permanent CBM review. Thank you, Senator Schumer. And adopting fee-shifting strategies as supported by Senators Hatch, Cornyn, and Grassley to deter frivolity within the patent system and to require trolls to put their money where their threatening mouths are. To conclude, Mr. Chairman, without a doubt, both small business and innovation drive the spirit of our economy and the nation, and both equally deserve to be protected from abusive patent trolls. We believe that a common sense, practical solution that protects all users of the patent system is indeed possible, but time is of the essence. The longer we wait, the longer we will expose innocent companies to the peril of trolls, which fly in the very face of entrepreneurship and fair play. We urge the committee to take definitive and bold action. Thank you very much.
My parents had, as you know, we've discussed it before, had a small printing business, the Leahy Press, which is eventually they retired, sold, but it is still operating in Montpelier, Vermont. But we certainly didn't keep a patent attorney on staff, and I can't think of many printing businesses that would, certainly not of the type you're talking about. I would think the manufacturer who made the product is in the best position to litigate. Have your members experienced this problem being targeted for products just because they're using them?
Absolutely, Mr. Chairman. It's the most frightening component of the patent issue, because innocent companies, small printers, small American printers that employ 20, 30, 40 people are being harassed by these entities claiming that they have infringed something. Printers don't go to work every single day, ladies and gentlemen, assuming that they're going to be dealing with a patent issue. It's not even on their radar screen. They purchase technologies, they purchase software from multi-billion-dollar companies, assuming that the due diligence is undertaken by those entities. And so for them to be held hostage with these shell letters is very intimidating, and it's reprehensible. We are all about protecting innovation in America, Mr. Chairman, but that doesn't mean that small businesses have to be pursued in a very predatory, very threatening way, and it needs to change, and we're very pleased to see some of the provisions that you and your colleagues have introduced.
I know that in general you'd like to see patent troll abusers stopped before any litigation actually commences, because it's risky and costly to engage in that litigation. However, do you believe that the proposals to strengthen pleading requirements, institute fee shifting, and impose some discovery limitations could have a beneficial impact in discouraging frivolous demand letters and reducing litigation, extortion, and abusive practices? And do you think that these reforms can make a positive difference? Mr. Macon and then Mr. Dwyer. And that'll have to be my last question.
Thank you very much, Senator Grassley. We absolutely support the measures that you've introduced. We do believe they will curb the activity. Again, I stress that we need to have a balance in the system that preserves innovation, but also does not hinder the growth of jobs in this country, which is the small business community. No printer is going to go out of their way to purposely infringe upon an issue. So all of the measures, heightened pleading, all the fee shifting, they all make it more difficult for these vile creatures underneath the bridge to do the things that they're doing. It stops them from doing that. We're not against people having the ability to protect legitimate innovation in this country. What we are against are companies that purchase antiquated patents for the sole purpose of extorting money from small business. That is anti-American, and it's just wrong.
Yes.
The notion of everyone having access to the courts is great, and it's part of the American system, but unfortunately, you have to have money to do that. And small businesses are not equipped to utilize the current court system in this situation. And it's really, as we continue to debate the merits of whether we're going to disenfranchise this community or disenfranchise that community, we're going to continue to see innocent players hurt. Innocent players so hurt that they could actually go out of business because...
I've been very concerned about the problem of patent trolls for years, and I think it comes down to two problems. One, there are poor quality patents out there being abused, and most businesses, especially small businesses, cannot afford to lay out the legal costs to see if they can win. Another way to put it is this. Getting hit with a patent lawsuit is like being forced onto a highway that has only 2 exits, both of which exact a high toll. You can pay the plaintiff either as a settlement or in licensing fees, or you pay your lawyers to litigate the case and hopefully win. We all know that patent litigation costs a fortune. It's often marginally cheaper and certainly less risky for a defendant to pay up front and make the case go away. So it's no surprise that the patent trolls take advantage of this, and there's a cottage industry of patent trolls now. This is particularly galling when patents are being used to sue are of poor quality to begin with. A recent PricewaterhouseCoopers study noted that patent trolls lose 85% of the time when they assert business method or software patents. But we never see that most of the time because small businesses can't afford to call the trolls on their bluff because of the high cost of litigation. 85% are not good patents. That's outrageous. My concern over this issue is why I fought to have Section 18, the Schumer-Kyle Covered Business Method Patent Program, included in the America Invents Act. And the CBM has worked. Everyone agrees it's worked. It's provided a cost-effective administrative review for the types of poor-quality patents that cover intangible methods of doing business. The existing review program under Section 18 has only been operational for about a year. It's working well and as intended. Nearly 100 requests for review have been made with the PTO, and the cases are proceeding smoothly. So the CBM provides a cost-effective off-ramp from the patent litigation highway. That's why I introduced the Patent Quality Improvement Act earlier this year to expand it and make it available to all poor-quality business method patents, not simply those that read on financial products or services. We need to make it permanent. The expansion of Section 18 is especially important for small businesses who can't afford to engage in lengthy litigation in hopes of prevailing. For any business that actually has been sued, it provides a cheaper exit strategy. More broadly, the very existence of this off-ramp discourages patent trolls from suing using invalid patents. If a troll knows he can no longer trap a defendant in expensive litigation, his interest in the suit will diminish. At the end of the day, if we don't address the fundamental problem of patent quality, trolls continue to abuse poor quality patents and we'll be right back having the same debate. A patent reform bill that does not address patent quality is like treating the symptoms instead of the disease. I understand my proposal is not without detractors, but if anyone thinks they have valid patents, they shouldn't be afraid of a preliminary proceeding. The only people who are afraid of this are who know their patents aren't valid. And it's really a shame that those who believe in valid patents are so strongly defending the invalid patents as well. I find that appalling, frankly. So, let me ask a few questions of our witnesses. I don't have too much time left. Mr. Macon, I was pleased to see an endorsement of the CBM expansion in your testimony. I'd like you to explain why it's helpful for businesses like those, like your members, to have it.
Thank you, Senator Schumer. Obviously, we applaud your fortitude on this issue. It's not a politically popular position, but we think it's the right position. You're exactly right that small businesses in America are being held hostage by the patent trolls. who count on leveraging fear and the fear of the litigation system to their benefit. They want people to settle. They want the low-hanging fruit. They want to intimidate people. Senator Tony Soprano has nothing on these patent trolls. They are thugs and reprehensible entities. And for us to just debate the merits of very esoteric patent legislation when real people in this country are hurting through no legitimate fault of their own, it's un-American and it's wrong. And so we do need to have off-ramps, to use your eloquent words, to be able to get out of that system. We want to avoid litigation at all costs. Small companies, printers, you name it, they are not interested in going into litigation. They're afraid. So all these measures after the fact of fees, et cetera, are too late. We've already seen the problem.
So your words were very strong, Mr. Macon. I tend to think they were appropriate in this particular case. And
okay, so heard it from an authority that this is a major issue. His testimony and some of my presentations, and I hope that that video gives you a sense of how serious this particular issue has become. So, who's really affected? The industry segments that are affected. It's the hardware and software producers. They're very vulnerable. To a certain extent, the content creators, which are really the designers, the marketing people, and so forth, but more so the service providers, which are the printers and related companies that are providing services using technology that supposedly is covered by certain patents. More specifically, the companies that are highly affected are commercial printers, small, medium, and large size, in-plant printers, specialty printers, and as you heard, these companies never dreamed that they'd be involved in having to defend their technology because of alleged patent infringements. So how do you deal with this? How do we deal with this? A lot of the cases that I've been involved with as an expert witness has to do with invalidity. In other words, looking at existing patents and determining whether they are valid or not. And we do this through the discovery of prior art. So let's talk about prior art and what it is. What is prior art? What is the value of a prior art search? Where can prior art be found? And how do you identify prior art to invalidate existing patents? First, let me talk about categories of prior art. I have 4 categories. There are a few others, but these are the main ones. Well, existing patents represent prior art. In other words, patents that relate to a patent that's under investigation, that's being looked at. Previously produced patents, okay, represent prior art. Industry publications, where there have been articles published about the technology that patents teach, is considered prior art. Conference proceedings, what people say at conferences, what's published from conferences, represent prior art, and even advertising represents prior art. Advertising of products and services that patents teach could be used as evidence that knowledge of the technology that patents teach was available many years before the patent was even filed for. So, what do juries understand and identify with? So once you get to a jury, once a case goes to trial, and most of them get settled before you go to trial, you've got to come up with prior art that juries understand. Now, I'm going to give you, this is a little bit anecdotal. There was one case, a big case I was involved with, where we went to trial. There was a 12-person jury, and we came up with prior art. I discovered prior art in Encyclopedia Britannica. This is something that people understand. Encyclopedia Britannica is a publication that you know, a jury with any background will understand the credibility that's often associated with this encyclopedia. Well, there's a technology involved, and 3 years in a row, the annual edition of Encyclopedia Britannica published an article about this technology. We presented this to the jury. This opened their eyes. They understood the significance of something being published and endorsed by Encyclopedia Britannica. Another would be well-known publishers, such as like McGraw-Hill. McGraw-Hill has an Encyclopedia of Science and Technology, and actually I'm the author of the section on printing, which covered some of the technology involved in a lawsuit that I was involved in. And we presented this to the jury. That they understood, okay? And then other popular media, if you can come up with prior art that's in popular media, people understand this has a positive impact on juries who are going to make decisions on whether these patents should be nullified or not. Now, you might say, well, you know, shouldn't the Patent and Copyright Office be able to come up with prior art? Shouldn't they be able to do these investigations? Well, they can to a certain extent. They're good at coming up with prior art patents, previous patents that relate to the technology of a patent under question. But they're not good at coming up with prior art for esoteric technologies in areas where there are patents, but there's also other information about that technology. And the area that I work in, graphic communication, printing, publishing, and this sort of thing, there are esoteric technologies involved. And if the prior art is not disclosed by the patent applicant at the time of application, it's very possible that these esoteric pieces of information will never emerge until a patent is challenged, okay? So the patent examiners, they're not always knowledgeable in the technology being examined. And also, they're under time constraints. The patent office is a big bureaucracy in Washington, D.C. These people, they're pressed to get these patents approved quickly. There are time constraints in completing examinations and so on. And again, they're not always aware of where to find prior art on esoteric technologies. That's where people like myself come in, and specialized libraries come into play, and other experts come into play. So what are we doing at Cal Poly? We recognize this big problem, and let me tell you a little bit about who we are and what we do. First of all, Cal Poly, very quickly, is a learn-by-doing university. We're laboratory focused. We have very professional faculty and staff who come out of industry. They're not only professors and researchers and writers, but they're also people who have worked in the field. We have an advisory board of leading executives around the country who participate with us. We provide services to industry, and one of our latest services is having developed a searchable database for prior art and other literature. So what are the services that we provide to industry? We have a Graphic Communication Institute at Cal Poly, where we do research, testing, product evaluations, training, seminars, workshops, conferences. We do publishing. Now we do literature searches. And the literature search capability came about through the development of a very specialized library that I referred to earlier on in this webinar. It's been 2 or 3 years in the making, and it's finally come to fruition. It's being used. It's housed at the university, and let me tell you a little bit about it. So as I said before, it's called the Raymond J. Prince Graphic Arts Collection, and it also features other specialized collections. And what I have here in this slide is a list of specialized collections that have been donated to Cal Poly's Graphic Communication Department. And this collection is available not only to students and professors, but to anyone in industry. Anyone can use this. It belongs to the industry. That was a specification of Ray Prince when he got involved in helping to put this together. So we have the Art Diamond toners, inkjet, and photoreceptor collection. Art Diamond is a very famous personality in the inkjet and photoreceptor and toner industry. Printing Industries of America donated what was their largest graphic arts library in the world. The E.H. Wadsworth Memorial Library Collection is now housed at Cal Poly. We had our own rare books, and we also, previous to this collection, had a resource room with books and publications in the name of Ray Prince. Dick Fish, or Richard Fish, is a famous scientist who had a very elaborate and very large collection of science and technology publications. He donated them. We have the Michelin collection of Recharger publications, and then we have our own historical Shakespeare Press Museum publication. Over 30,000 titles going back over 200 years. We can find information on virtually any topic, any technology that exists today in the graphic arts or existed previously. So how do people use this collection, and how can it be used for prior art? Well, here are some few examples. A company offering a new product wants to be sure that it's not violating existing patent. They can come to us and have us do a search for prior art that assists them in this endeavor. Or they can come and they can spend time at Cal Poly. They can come and work on their own in this library to find what they're looking for. Companies being sued for using a technology that allegedly violates an existing patent and wants to search for prior art that disqualifies the patent in question. This library is designed to do this. And then, of course, it has an academic application. A student doing research but doesn't have access to pertinent literature in the field, or a professor or industry consultant writing a book or article wanting additional information and bibliographic citations for the material being referenced, can use this library for that purpose. So we have publications and resources for the industry. In some, we also offer meeting facilities, research and testing services, and of course the prior art and literature searches. And how do you go about accessing this collection? Any of you out there that needs to do research and wants to use this library? Well, all you have to do is get in touch with Lindy Singh. She's the director of the Graphic Communication Institute at Cal Poly. Here's her phone number, her contact information, email address, website for the institute that she's the director of, and she'll tell you how to go about getting involved. Either the institute can do searches for you, or you can come, if you want to come out to California. Those of you on the East Coast, come on out in January and February, and you can do your own searches, spend as much time as you want in this library. It belongs to you. So with that, ladies and gentlemen, we're here to help. And you can contact me at your convenience. Here's my email address and my direct phone number. I'd be glad to communicate with any of you at any time. And we're now opening up the webinar to any questions you may have.
Thank you so much, Dr. Levenson. We do appreciate it. And as the good doctor said, please type your chat questions into the chat box so that we can get those answered. We do have a couple that have come in. So, question from Joe: can I discuss details of my invention with a potential investor before filing a patent application?
Did you say with a potential investor?
Yes.
That would be a good idea, actually. Not only can it be done, but that would be a good idea, because this is something that the Patent and Trademark Office would look at. One of the things they look for is, in assessing whether to validate a patent, to offer patent, is how significant is the technology? Is there interest in it? These are called secondary considerations. Is there an industry need for this kind of thing? And if there are investors out there that say that yes, if a patent is offered and the patent holder wants to develop the technology that the patent teaches, and there's funding available to do that, that would be looked upon favorably in making a determination whether to offer a patent or not.
Great. Another question. This is from Carl. What is the best method to find out information for patents that have provisional submissions? Is there any visibility to those?
Yes. There is, if you go to the U.S. Patent and Copyright Office, you can access patents that were applied for. Okay, not only patents that exist, but patents that are being considered. Now, I don't recall the extent of the detail that would be provided on that, but you can certainly access the applications that are being looked at in the Patent and Trademark Office.
Great, thank you. Another question in from James. Do you believe there will ever be any end state for this troll situation, or is it going to remain as this constant battle?
Okay, that is the question. I mean, I don't mean this in a rhetorical sense. That's an amazing question, because the answer to that question is really points to the end point of this whole situation. So you saw that the issue is in front of Congress, okay? But Congress moves very slowly, and who knows how long it's going to take for a determination as to whether to develop legislation that's going to eliminate this whole patent troll situation. But in my opinion, the way to resolve this is through invalidity hearings. In other words, developing counter lawsuits that go after the patents that the trolls have and try to invalidate them through prior art. And I'll tell you, in the area of software, and that's where most of this action is taking place, because, as I said before, like, software is so intangible. It's not like something you could look at, you can feel. I mean, you can develop workflows and understand workflows that software require, but it's so intangible that it's really low-hanging fruit for these trolls. But software, what I found is that the technology of software that was developed many years ago is the same technology that's being used for relatively new software applications today. And the key is to come up with a series of prior art that a person of ordinary skill in the art would understand. Now, a person of ordinary skill is a term of reference that's used in patent litigation. So if you can come up with 5 or 6 items that relate to a patent in question, maybe a patent that's held by one of these trolls, and put it in front of a person of ordinary skill, and it could be a person who, let's say, in the graphic arts industry, has a bachelor's degree in printing, industrial technology, engineering, or some related area with maybe 3 to 5 years of experience, he or she would be considered a person of ordinary skill. If they look at these 5 or 6 pieces of prior art and say, oh yeah, if I put all of these together, I can figure out what this patent is trying to teach. That's a key to invalidating these patents. And you heard in my presentation and in the video that anywhere between 35 and 85% of challenged patents are won. I mean, that's like amazing. The odds are in favor of winning these challenges than losing them. But of course, the big problem is coming up with funding to get into the litigation game. But that's really the answer: is searching prior art that was not presented prior to the application of a patent to show that the technology of the patent was already known prior to the application.
Thank you for that. One question from Greg. Are patents valid across countries, and are the majority of patent trolls coming from the U.S. or are they coming from elsewhere?
Well, I'll tell you, the patent troll issues that I've been dealing with are coming from, the main one that's facing the industry right now is coming from the United States, okay? There are trolls that are coming from other countries, but not as many as from within the United States. Now, what's happening is that there are standards that are being developed that will apply across the board internationally, but those standards are in a developmental stage right now. There are a lot of unanswered questions about how patents developed in one country relate to patents developed in another country. There are questions about whether a patent developed in one country would be considered violated if the technology that's taught in that patent is used in another country. So this is an area where there are really unanswered questions, but it's certainly being looked at. And it is understood that it's to the benefit of all nations that if standards can be developed that apply across the board, just as in the INLSAT situation that I had mentioned earlier.
Fantastic. We only have a few moments left, and I don't see any other questions coming in. So if you have some questions that you think of later, please feel free to email them to ritalum@rit.edu or tweet them to @RIT_alumni with the hashtag #MeRITWebinars, and we will direct your questions directly to Dr. Levenson. Go ahead.
I will answer any question that you have following this webinar. Simply send an email. You can send it to RIT or directly to me if you want. Call me up if you like, and I'll be glad to discuss any questions or matters that any of you have regarding the topic that we covered today.
Thank you. That's very kind. As a reminder, everyone participating today will receive an email from us in a couple of days with a link to today's webinar recording. And many, many thanks to Dr. Levenson for being our distinguished speaker today. And thank you to all of our listeners for joining us on today's webinar. Our next webinar is in 2 weeks on December 2nd, and we will cover life-stage estate planning with Robert Constantine. While many of us may want to put off conversations about estate planning, it is never too early to ensure your loved ones are protected. Please check your email inbox for an invitation to this next Me or IT webinar event. And with that, I thank you all for joining us.